Good afternoon, it's 12 o'clock and I'd like to welcome you to the latest in the 5 series webinars from gunnercooke. My name is Richard Cannon and I'm a partner practicing in the business crime area at gunnercooke, located in our London office. Today's webinar is titled 5 Key Provisions Introduced by the Criminal Finances Act 2017. This is quite a heavy fact-laden area, and I will not be able to cover every aspect of the Act in the next 30 minutes. The idea of this is really to give you a heads up, an insight into the kind of areas which the Act deals with, and then, of course, here at gunnercooke, we can follow up with any specific queries that you may have or needs that arise. Okay, without further ado, what we're going to do today is look at, as I say, 5 key areas which I've highlighted arising from the Act, which came into law in the middle of last year, actually just very close to the division of Parliament before the general election. The 5 areas we're going to focus on are the inclusion of human rights abuses as a ground for property to be seized, unexplained wealth orders, which I expect some of you would have heard about in the press, the extension of moratorium periods in relation to suspicious activity reports. Number 4 is going to be new powers to freeze and seize funds in bank accounts by the Magistrates Court. I'm going to simply say here that in my view and those of some others in the field, that's the most significant power in this legislation, but more of that a little later on. And the 5th will be the new corporate offence of failing to prevent the facilitation of tax evasion. For those of you who are operating in the commercial sector in businesses on boards of directors, I would say that in terms of relevance, we're going to get more relevant as we go through from 1 to 5. The early areas are those which are more likely to be, in essence, headline grabbing policy related provisions which have been brought in to the Act. A little overview. The Criminal Finances Act pretty much amends the pre-existing Proceeds of Crime Act. That's apart from the tax evasion offence, number 5 on our list, which creates a new standalone criminal offence in the Criminal Finances Act. The Proceeds of Crime Act is and remains a wide-ranging set of powers which enable the state to pursue both civil and criminal remedies against the proceeds of crime and those individuals or organisations who are concerned with it. We're not going to be talking today about the criminal aspects of the Proceeds of Crime Act. Those include the money laundering offences and confiscation proceedings which follow convictions in the Magistrates or the Crown Court for any offence or a wide-ranging number of offences. What we're going to be talking today really in relation to the Proceeds of Crime Act is the civil avenues which are open to the state. And as you can see from this slide, the umbrella term is civil recovery. They don't require a criminal conviction, and there are 2 avenues, 2 gateways really into these powers, which are in the jurisdiction of the High Court and the Magistrates Court. The trigger for civil recovery is there must be identifiable property which is obtained through unlawful conduct. And unlawful conduct is something which is defined by the Proceeds of Crime Act. Onto our first key area, the extension created by the Criminal Finances Act to the definition of unlawful conduct by including human rights abuses. The background to this really is the global activity of certain countries into trying to police torture and other human rights abuses and attack the perpetrators of such by attacking their assets in their own jurisdictions. This has been for a long time championed by the US and the UK and other actual Commonwealth countries. Australia, excuse me, have been catching up. So the Criminal Finances Act now extends the definition of unlawful conduct to human rights abuses. This is conduct which is a gross human rights abuse or violation outside of the UK, and if it had occurred in the UK, someone could be prosecuted for it. We'll take a pretty whistle-stop tour through the definitions, but essentially the conduct complained of must constitute torture. And it's not torture of anybody, it's torture of somebody who has sought to expose the illegal activity carried out by a public official or to obtain, exercise, defend or promote human rights and fundamental freedoms. So as you can see, this is very much attacking those agents who have committed human rights abuses against people who are often involved in political process or political activity. The torture must be taking place because of the victim's place in challenging or promoting fundamental freedoms, and must involve the acquiescence, the agreement, the promotion, the authorization of a public official. In other words, essentially that means state-sponsored. Again, this slide just follows that through to say that it includes persons who are acting as an agent for another, directing or sponsoring such activities, profiting from such activities, or materially assisting such activities. The summary for this new extra provision is essentially that the UK government now has the power to go after the assets of those who are in some way connected with the violation or abuse of the human rights of political activists abroad, and is seen as a helpful weapon in trying to curtail that activity. We will have to see how many occasions there are when this power is actually utilised, but as I've said, I think some of the powers which I'm going to talk about at the beginning of this broadcast really are as much about promoting the idea as perhaps the actual implementation on the ground. That fits the bill perfectly for the unexplained wealth orders. Of all the provisions in the Finances Act, this is probably one which has received most media attention. You might recall that during the Salisbury incident, there were some calls actually from Parliament that unexplained wealth orders should actually be used against Russian nationals. It would be unlawful to simply use unexplained wealth orders against somebody because of their nationality. But we'll have a little look about at unexplained wealth orders now. Now, the background to unexplained wealth orders is that they are a gateway, a prequel really, to the proceedings in the High Court of Civil Recovery, which I referred to at the beginning. What they do is establish almost a pre-action disclosure power, which the law enforcement agency can use against the individual to try to tease out of them by compulsion details about where their wealth has originated from. The unexplained wealth order is issued by the High Court, and it is a requirement, as I say, for the named party to set out the nature and extent of their interest in the property identified. They must also explain how the interest was obtained, including details of how it was funded. There may be requirements to provide information and produce documents. Key is that if the unexplained wealth order is not complied with, there will then be a presumption under the law, in other words, a big legal box ticked that this property is now recoverable under the civil recovery powers in the Proceeds of Crime Act. In other words, this means the state are almost home in those proceedings before the starting whistle blows. Therefore, for those faced with unexplained wealth orders who may be reluctant to provide explanations, the risk is that they lose the property that they are going to, that is an issue, were they to refuse to give any details about its origins. For the the High Court, to grant the order, they must be satisfied of the following three conditions. The first is that the property concerned is valued at greater than £50,000. As the legislation passed through Parliament, this threshold was lowered. I think it was originally at 100,000 and came down steadily to 50,000. It's important to note that it's the person concerned's interest in the property which must exceed 50,000. Therefore, if it's a jointly owned property, the property itself may be worth a lot more, but as long as that person's purported interest is in excess of 50,000, then the provision will bite. Additionally, the value of 50,000, the threshold, can be aggregated over more than one item of property. So if we have a number of items of property valued at less, but they add up to more than the 50,000, then the threshold has been reached. Personally, I think it's extremely unlikely that the National Crime Agency, who are likely to be the most prominent agency using these powers, would launch into an unexplained wealth order for a property valued at anything close to 50,000, because it's purely just not economical for them to do so. It's not a commercial piece of litigation. It may be that there are other good policy, political or strategic reasons to go ahead, but as a piece of litigation commerce, 50,000 I would have thought would be unlikely to trigger what could be quite an expensive piece of litigation by the state. The second ground is that there are reasonable grounds to suspect that the known sources of the respondent, that's the person's lawfully obtained income, will be insufficient for enabling them to obtain the property. In other words, people are living beyond their means. They live expensive, high net worth type lifestyle with very little visible lawfully gained assets to show. It's interesting to note in relation to this particular ground that one of the agencies who are permitted to bring proceedings under this head of Her Majesty's Revenue and Customs, and you might think that they would be ideally placed to make an assessment of somebody's lawfully obtained income because they're seeing everybody's tax returns, assuming, of course, that they're domiciled in the UK in the first place. The third ground, and I'm going to take the second one first, there are two limbs to this. One, that there are reasonable grounds to suspect the person connected with the respondent is or has been involved in serious crime. And the other is that they are a politically exposed person. And this is quite an interesting area. They must be a politically exposed person who are outside of the EEA, that's the European Economic Area, and that's basically the EU plus Iceland plus Liechtenstein and Norway. And what is a politically exposed person, or PEP? The definition for that, and I'll read it, is somebody who is entrusted with prominent public functions by an international organisation or by a state. Very, very wide. Well, the definition gets even wider. It includes the family of that person, a close associate of that person, and if that wasn't enough, it also includes somebody who is otherwise connected with that person. So the net in relation to a non-EEA PEP is very wide, and it's no surprise that people have talked about unexplained wealth orders, particularly, as I said, in relation to issues involving Russian nationals and persons from those areas. I mean, no comment on that other than to say the Act is set up, poised for action to be taken in those circumstances, and there have been one or two, we think, unexplained wealth orders already made. I'll whiz through these bits. It doesn't matter whether the property is jointly owned, it doesn't matter where it's located, anywhere in the world, and the party concerned can also be outside the UK. The government's view is that this order will smash through any corporate veils that the person concerned has put up, including offshore structures. And it's key also to bear in mind that if somebody recklessly or deliberately makes a statement in response to an unexplained wealth order which is false, 2 years imprisonment might flow. It's an offence in itself. Okay, we're going to move on to number 3 in our list. I hope that people who are listening or catching up with this webinar will be aware what a suspicious activity report is. A SAR, mainly issued by the regulated sector. What a SAR does to the NCA is it essentially provides an opportunity for a defence under the substantive money laundering offences for a transaction to take place. They are regularly made, often by financial institutions, law firms even make them, and other regulated entities, but can also be made by non-regulated entities. In terms of scale, it's important to note that in 2017 there were, that's in the last calendar year, approximately 417,000 SARs made to the National Crime Agency. My rough calculation on a working day is that's over 2,000 SARs a day. So this is a extremely prevalent activity. It's an extremely time-consuming activity for the National Crime Agency. The process is a little bit complicated, and I'm going to flick through it and explain what happens. If somebody wishes to make a suspicious activity report, in other words, to seek consent for a transaction that they are involved in, let's say it's a bank, let's say it's a conveyance, and they've been asked to pay £1 million through their account for the purchase of property, and they have concerns about the origins of that. Of those funds, they make the SAR. The SAR then from the next business day kicks into a 7 working, that's business day, moratorium period. The moratorium period is 7 days for the National Crime Agency to decide what to do. There are 2 outcomes from this, but three ways of doing it. They may consent to the activity within the 7 days and say, go ahead. That provides the defence to whoever has made the SAR under the money laundering provisions, were there to then be a problem later down the road. They may say nothing to the maker of the SAR, silence. After 7 working days, that is deemed consent. It's as good as in law, the NCA giving explicit consent. The other alternative is that the National Crime Agency will grant a refusal. That is, they will say you are not permitted to carry out this transaction. In those circumstances, we enter a further moratorium period of 31 calendar days, not working days, but calendar days. That was a law, settled law from the Proceeds of Crime Act 2002. 31-day calendar moratorium period couldn't be extended, and essentially it was an opportunity for the law enforcement agencies, the government, to launch proceedings, often under the Proceeds of Crime Act themselves, in order to seize and or freeze the funds concerned, or take any other action that they thought appropriate, normally maybe a restraint order, a freezing order, or all the other provisions that are available to them. If the 31-day calendar period expired, then again, consent was deemed and the agency involved, whoever made SAR, was free to carry on. Now, the position has changed. The position now provides for an extension of the 31-day period for a number of times. It's actually up to 6. The rules are quite complicated, and I'm not going to go through them at length today, but what it means in practice is the following. Where a SAR has been made, let's go back to our bank and our conveyance example, the parties are not permitted to be informed by the author of the SAR, because that could be the criminal offence under the Proceeds of Crime Act of tipping off. You can imagine a situation where you're getting close to the completion of a transaction and the bank goes quiet. No money's being moved, and they can't and won't say anything at all. That's bad enough for 7 days. It's really a problem for 31 days, but the law now allows for that 31-day period to be extended through a application made by the National Crime Agency to the Crown Court for a number of different 31-day periods. The maximum of those goes up to 186 days, and if you include the initial moratorium 31-day calendar and 7 working days, which is probably 9 calendar days, you're talking about now a maximum of 226 days. anybody in commerce, I'm sure, would agree that after 226 days of silence, the deal is dead. We expect this power really to be used in rare circumstances, but that is merely a prediction. We don't actually know on the ground how this is going to take effect. But you can imagine once it gets running, it's going to cause some serious difficulties, both for those involved in transactions and those actually who are involved in making the suspicious activity reports. The grounds are set out on the slide. They're relatively low hurdles. The investigation is continuing. The investigation is being conducted diligently and expeditiously. The diligent and expeditious grounds are those which appear throughout the criminal legislation in a number of different powers. The third is that further time is needed for conducting the investigation. You might think that's self-evident if the application is being made. And then our catch-all is that it's reasonable in all the circumstances for the moratorium period to be extended. I'm going to add one other observation, which is that this is not a process where necessarily all interested parties will have a seat at the table. The subject of the SAR, that is, where the origin of the funds which are suspicious is coming from, may be excluded from the proceedings and may indeed have no notice that this is going on at all. Okay, we're going to now move on to the fourth in our list of provisions. As I mentioned earlier on, for me, this is probably the most significant provision from a legal perspective and a practice perspective. A little bit of the history of this provision. We're going all the way back to 1994. We're going back to the Drug Trafficking Act, which was the first act really which introduced the power for law enforcement to take money at source away. In the Drug Trafficking Act, the power existed in the Magistrates' Court, as it now still does, but it was in essence cash seized as a proceeds of drug trafficking that was being imported or exported. So it was often a customs border activity, and the thresholds have come down and down and down. The Proceeds of Crime Act extended that power a little bit and made it applicable to money seized anywhere. So what this was really talking about excuse me, was where the police in the course of their activities come across cash and need a ready and quick fix in order to bring it under the court's control. What the provisions allowed basically was for a constable to seize funds and go down to the magistrate's court the next day and apply for the money to be detained. The new powers have extended this provision way beyond those envisaged by the original creators of the Act. The power now provides for the forfeiture of money held in bank accounts. This used to be the pure jurisdiction of the High Court, and this law now leapfrogs jurisdiction all the way down to the Magistrates' Court. The first step in the circumstances is for an application to be made for an account freezing order. The court must be satisfied that there are reasonable grounds for suspecting the money held in the account is recoverable excuse me, and is intended by any person, or is intended by any person for use in unlawful conduct. That means either it's the proceeds of unlawful conduct or it is going to be used in that regard. The application can be made without notice, so the holder of the account knows nothing about it, if the circumstances are that notice of the application would prejudice the taking of the steps to forfeit the money. And you can imagine that argument being made quite readily by the police or whoever makes the application. The maximum period the account can be frozen is 2 years, an awful long time. The minimum amount for these proceedings is £1,000. Once the initial order is made, notice would be served on the holder of the account. There are provisions for reasonable living expenses to be taken from the account to carry on trade, business, profession, and of course the payment of reasonable legal expenses. But extraordinarily, you might think, there is a provision that allows the court to consider the desirability of the person being represented in the proceedings. Once the freezing order is in place, within the 2 years, a senior officer can then issue an account forfeiture notice, and that's the provision by which the court basically can seize the money permanently. If no objection to that notice is received within the period specified, which is 30 days, then the money is automatically forfeited. There is another 30-day period for an aggrieved person to apply for the forfeiture to be set aside. Then we enter into basically a contested high-level proceedings in the magistrates' court. There, as far as I'm aware, been no provision for specially trained magistrates to deal with these matters. The application for forfeiture automatically extends the freezing order, so you can imagine the circumstances when the account freezing order has been in place for 1 year, 11 months, 3 weeks and 6 days, and the police make an application for the account forfeiture notice, or issue the account forfeiture notice. That would then extend the freezing order until the matter is determined, which one suspects would then be a considerable time. All of the time, the account is frozen. We'll have to see in relation to that power quite how much it will be utilised. My view is that it will be the most utilised power in the Criminal Finances Act. It will be groundbreaking and will be made of great use by lots of law enforcement agencies, including, for example, trading standards. We're now turning to the corporate offence of failure to prevent the facilitation of tax evasion. This is a standalone criminal offence which comes out of the Criminal Finances Act. In a sense, it's an extension of the concept that was established by the Bribery Act, which is, in a nutshell, that if criminal activity takes place within the ambit of responsibility of a corporate, and the corporate has failed reasonably to prevent this activity taking place, then the corporate itself is committing a criminal offence. The extension here is in relation to a tax evasion offence, but it's not tax evasion committed by the corporate itself. It's not tax evasion committed by an associated person of the corporate. It's the facilitation of a third party's tax evasion by an associated person. And I'll take you through what is quite a complicated concept, step by step. Stage one, there is tax evasion by a taxpayer. This can be either an individual or legal entity, and it's under the existing law. And it can be anywhere in the world. The second stage is that facilitation, that tax evasion is facilitated by an associated person of the relevant body. We're going to come back to what an associated person is, but it's a frighteningly wide definition. And it's that person acting in that capacity. So in other words, acting in the capacity of their connection to the corporate concerned. And stage three is that the relevant body, and I'm going to talk about corporates, has failed to prevent its representative from committing the Criminal Facilitation Act. And there's a reasonable defence, such as there is in the Bribery Act, and that is, and I'll read it, where the relevant body has put in place reasonable prevention procedures to prevent its associated persons from committing tax evasion. Reasonable, for those who are particularly interested in this area, is an amendment from the Bribery Act which used the word adequate. I think reasonable is a better word. Adequate could arguably be failing each time there is an offence, because clearly it wasn't adequate to prevent. So reasonable, I think, is a fair word to be used, and I don't think causes much movement from the original concepts. So an associated person, that's the person who has facilitated someone else's tax evasion. Their connection to the corporate can be as follows: an employee, that's easy, an agent, acting in that capacity, and any other person who performs services for on behalf of the company. And that, per se, especially if you're dealing with a company which has an international relationship and doing relations overseas, can be very wide. I'm going to skip through the next definitions because we're into the technical area of criminal tax. But essentially, a tax facilitation offence in the UK means any of the criminal statutes which deal with tax evasion, such as fraudulent evasion, aiding, abetting, counselling and procuring tax evasion offence. That's a cheat on the revenue or fraudulent evasion again. The foreign offence, generally speaking, the foreign tax evasion has to be an offence in the country where it's committed, and there is a corresponding offence in the UK. Now, how does the corporate tackle this problem? Well, HMRC have issued guidance, which we're going to have a little look at. It's essential that the corporate carries out a risk assessment prior to the implementation of any policy. There's no one-size-fits-all option. Some corporates might conclude that it's not reasonable for them to have a policy at all, but it's difficult to see this being a sustainable position for any corporate where high or even medium risk factors are present. But if a corporate was to decide that it wasn't appropriate for them to have a policy in this area, that in itself needs to be backed up by some kind of process which will reach that conclusion. As I say, HMRC have provided guidance to assist corporates in their development, implementation and execution of what they're calling prevention procedures. This was issued very, very close to the implementation of the Act. This offence came into law on the 30th of November, the 30th of September 2017, and actually the guidance was issued some weeks before. The guidance highlights 6 principles in relation to the risk assessment or the policy. They are: carry out a risk assessment, proportionality of risk-based procedures, top-level commitment, management down, due diligence, communication including training and monitoring and review. These principles are not meant to be prescriptive, and HMRC is helpful but also unhelpful in saying it's up to you to get it right, but corporates must apply them according to their circumstances, their industry and their businesses. The process should be well documented. That's really important because the company will want to rely upon it in the event of any investigation or prosecution. It should be measured and proportionate. There's no prizes for volume here. If an appropriate risk assessment has been carried out, then the more brevity to the policy, the better. The more focus, the better. This is not a situation, I would say, where a policy can be drafted and left to gather dust unless and until HMRC come knocking. Performance against it does need to be monitored, with the corporate being open to amending the policy as the business evolves and develops and their risk profile does as well. Okay, so we're coming now to the conclusion of the seminar. I just want to talk about the facilitation offence once more. This carries an unlimited fine for the corporate, and it should be noted that is covered by the DPA provisions, which allow for a company to negotiate a deferred plea arrangement agreement and pay a sum of money and basically enter a cleansing process under supervision of the court. You may have read about those, for example, with Rolls-Royce and Tesco, occurring under the auspices of the Serious Fraud Office. We'll have to see whether there are any or many prosecutions under this particular provision, and then whether this is a source of DPAs. But it's worth considering the impact that the Bribery Act has on corporate governance, and really what the government is expecting through HMRC is that this will have a similar effect on the way that companies organise themselves and deal with risk in this particular area. Well, I've tried to cover all of these 5 areas in the time allotted. We've run over a little bit. If you have any questions or want any specialist advice, or even just to engage in a conversation about anything about this, you can contact me on the email address at the bottom of this slide, richard.cannon@gunnercooke.com. Thank you to all those that have joined us, and I hope you enjoy the rest of your day.